Okay, so we're going to be starting out with the next topic that is known as mens rea. Now, what is this word mens rea? It is taken from this particular legal maxim, as you can see before you, actus non facit reum nisi mens sit rea. That is, an act itself is not wrong in the absence of a guilty mind, or the act itself creates no guilt in the absence of a guilty mind. So till now we saw in the general conditions for liability in a tort that there must be a wrongful act or an omission by the defendant which gives rise to a legal damage against the legal injury that is being caused. But the concept of mens rea, or this maxim actus non facit reum nisi mens sit rea, goes on to say that the act by itself is not wrong unless it is accompanied by a guilty mind. So generally, if there is to be a wrongful act, then only if it is accompanied by a guilty mind can that activity itself be a wrong activity. So for this purpose, we try to understand how much of a guilty mind is required before a person can be punished under law. Okay. In law, we will classify mens rea in two aspects, from the point of view of criminal as well as civil. Now, when we look at criminal laws, the amount of mens rea to be proved is very high, in the sense that only if you establish that he had a guilty mind can a person or an accused person be declared guilty under law. So if a person is doing an activity with no guilty mind, then we can say that the level of punishment or the level of the amount of imprisonment that he gets will be much lesser or much lower. But for that we need to establish a very high level of mens rea. They say that he must be proved guilty beyond a reasonable doubt. And you have to establish very clearly that he had the guilty mind, and with this guilty mind he carried out the activity which was the crime and for which he is being punished currently. But then for civil matters, the mens rea to be proved is either very low or non-existent, in the sense that the level of mens rea to be proved is very, very less. I'll give you examples for both of them. Say for example, we have in a criminal case. In a criminal case itself, I will give you two examples for the sake of better understanding. In the first scenario, we have a person who has gone into a store and bought a very sharp knife. He has taken that knife and walked straight into his ex-girlfriend's house, knocked on the door, and as soon as she opens the door, he stabs her 10 times. This is the first example. In this example, you can clearly see that he had every intention to kill his ex-girlfriend, because he has gone to the store, bought a very, very sharp knife. He has gone to her house, presumably knowing that she is living there at that time. Once she opens the door, he kills her, he stabs her 8 times. So the act of stabbing once can probably be said to be a mistake, but the action of stabbing 8 times can never be established as a mistake, that it can only be done with the intention of killing that person. So over here there is a very high level of mens rea for this particular example. Now let's look at the second example. In the second example, let's say a person is traveling from Coimbatore to Bangalore, and for the purpose of travel they decide to start very early in the morning. This person gets into his car at 4 AM in the morning and he starts driving on the highway. By around 5:30 AM it's still dark outside, and he's going quite fast on the roads because it's empty and there is no traffic on the roads. He doesn't see a pedestrian crossing due to the insufficiency of light. He ends up hitting this person and this person is gravely injured. Now tell me, in this scenario, is there mens rea? Technically, there is no case of mens rea over here, or a very low level of mens rea, because when he got into his car at 4 a.m. in the morning, he did not do so with the intention of killing a person that day, but rather it happened by accident, or it happened by mistake, that at 5:30 he ended up hitting a pedestrian on the road. So while he will be given a certain amount of punishment, he will not be given the maximum level of punishment, because there is actually no case of mens rea, or the amount of mens rea is very, very less, because at the end of the day he still has a duty to drive responsibly on the roads that he is driving on. So this is the case of mens rea to be proved in a criminal case. But what about civil? Let's take, for example, civil cases where you are driving on the road. You are the owner of a two-wheeler, a bike, and you are driving on the road. Now, the Motor Vehicles Act or the road safety rules mandates that you have to wear a helmet at all times on the road, and you should be carrying a valid driving license with you. Now, you happen to be going on the road, but you're not wearing a helmet at that time. For whatever reasons, you may think that the distance is very short and you have chosen not to wear a helmet. Now at this point, tell me, does the action of not wearing a helmet amount to mens rea? The answer is yes, because you know that you have to wear a helmet, but you chose not to wear a helmet. So that by itself is mens rea. But tell me, if you get caught by a traffic police, do they stop you on the road itself and instantly charge you a fine? Or do they stop you, take you and your vehicle to the nearby magistrate or to the nearby court and get the judge to impose a fine on you? The answer is, you will be fined on the spot. You will be fined without even establishing whether you had a guilty mind or you didn't have a guilty mind. Regardless, you will be punished for the crime. So in criminal cases where it was necessary to first establish mens rea before you are punished, but then in civil cases you need not even prove any amount of mens rea before you are being punished. You will be punished instantly regardless of your guilty mind, or even the level of mens rea to be proved will be very, very less. That if you simply show a reasonable amount of doubt regarding the fact that you committed this civil offense, that itself attracts a civil penalty. So keeping this in mind, let's look at how mens rea can be interpreted in two ways. Please also understand that currently we are not looking at the concept of criminal law, okay? That we are only looking at the concept of civil law, because we're talking about law of torts, which is merely an extension of your civil laws. They're saying that first and foremost, the fault or the state of mind, when is it relevant? Or in short, when exactly is mens rea relevant or required to be proved? In torts like assault, battery, false imprisonment, deceit, malicious prosecution, conspiracy, the state of mind of the other person is taken into account to ascertain his liability. So his actions, his conduct, etc. determines the level of mens rea in this particular scenario. But then there are cases where there is liability without fault, where the mental state of the doer is completely irrelevant and liability still falls on the shoulder of the doer. Okay, so what did we say? A wrongful act or omission plus a guilty mind is only equal to punishment. Now there are some cases, that is in point 1, where the guilty mind is required to be proved. But then in liability of fault, they are saying that this factor is completely irrelevant. That simply if the wrongful act or omission was done, I will outright punish you for the same. Now, these concepts are not used everywhere. It is not used in all cases of a civil wrong, but rather two specific cases that we see as are strict and absolute liability. So this is what we're going to be looking at now, strict and absolute liability. Now, the word liability means some kind of obligation. Okay, and we see this liability from three aspects. The first one is strict liability, the second one is absolute liability, and the third one is vicarious liability. Now, for vicarious liability, we look at it from two concepts. That is, one is the general principle and one is the vicarious liability applicable to the state, or in other words, to our government. Okay, so let's look at what this principle of strict liability and absolute liability is. Now, to understand your strict and absolute liability, we have to move backwards. That is, we first have to look at a disaster which happened in our country, that happened in something known as the oleum gas leak case. Many of you all will also know this tragedy as the Bhopal gas tragedy. What happened in this Bhopal gas tragedy? In the Bhopal gas tragedy, there was a company known as Union Carbide, which was holding a certain poisonous gas within its premises. Now, the nature of the gas was such that if it comes in contact with air, then it will convert into a gaseous form, that is in vapors, and those vapors can be highly harmful to the people who breathe it in. Now, this on that day of December 3rd, what happened was, due to some factors that is still not clear about, the gas ends up coming contact with air, becomes of a gaseous form, and ends up spreading to a very large amount of area around the factory premises. This went on to spread on to for at least 10 to 20 kilometers, if I'm not wrong, in the nearby vicinity, and the wind also helped move the gas to nearby areas. All the people who breathed the gas, especially within the factory, have passed away. All the people who were in the vicinity of the factory, that is even like 5 kilometers away from the factory, had such severe problems that most of them passed away, and the remaining were so crippled for life that nothing could be done to save them. But the tragedy didn't stop over there. All the persons who were affected by this gas, if they had children, or if children were born post being affected by the gas, even the children were being affected in terms of physical disability, unable to breathe, and symptoms which were beyond the control of our doctors to provide help for. So this tragedy proved to be a very, very severe tragedy in the history of India. And when such a tragedy happened, a person named MC Mehta, he was an environmentalist lawyer who ended up filing this case in the court of law, trying to seek some kind of a remedy for the victims of this Bhopal gas tragedy. Now, when the courts tried to look at this point, they were unclear of how to provide a certain remedy to the persons or to the victims. Why exactly did this happen? It is because the company itself tried to take multiple defenses, so as to say that it was not their fault, or that they had no intention of causing so much harm, or that it was the fault of the employee who was in charge of handling the chemicals within the factory, and that due to his fault the gas had leaked. Now it was very easy for the company to simply point fingers and blame everybody else, but the truth of the fact was millions of people were being affected by this, particular tragedy. So if we have to follow the original sentence, that is, if there is a wrongful act, it is not a wrongful act if there is no guilty mind. Now over here, Union Carbide was simply trying to say that there is no guilty mind on our behalf. So therefore this does not amount to a wrongful act, and therefore you cannot punish us. But then again, the facts of the case are, there are thousands, millions of victims who need some kind of compensation for the harm caused to their body. And so what our courts did was, they borrowed a rule known as the strict liability principle that was formed in England in the case of Rylance versus Fletcher. So our courts borrowed this principle of strict liability from England and applied or changed the principle a little bit so as to apply it to the case of the Bhopal gas tragedy case. So for that purpose, we're going to be looking at what amounts to strict liability and what amounts to absolute liability. Now, if you look at what exactly is strict liability, the strict liability falls under the following concepts. That is, the defendant is liable for some acts regardless of whether there is mens rea or not, or a guilty intention or not. So let's look at the case law of Rylance versus Fletcher for this purpose. Fletcher is the owner of a mill. Fletcher had appointed certain independent contractors who were competent to construct a reservoir on his land to provide for the water in his mill. So Fletcher has property. He's a mill owner, and he thought it was best to build a reservoir for the purpose of collecting water to supply to his mill. But what the independent contractors were not aware of was that there were some old disused mining shafts under the reservoir. So they're basically like tunnels which are going right under the reservoir. One day there was a very heavy rain that should or had gone to the very highest capacity of the reservoir. Now at this point, the mining shafts underneath the reservoir broke through and the water ended up flooding all of those tunnels. It so happened that these tunnels were linked directly to a village below. And so when the water flooded those mining shafts, the water ended up flooding to the village below and ended up causing damage to the properties, including Rylance property. So over here, Rylance has filed this suit against Fletcher for the damage that was being caused to him. Now at this point, the court went on to hold that, see, if any person is bringing anything unnatural onto their land and that unnatural thing escapes from his land, then he is doing so at his own peril. That is, he has a duty to, if he is bringing this unnatural thing onto land, he has a duty to protect it and to also ensure that it does not escape and cause harm to other people. Now, even if the thing does not escape or cause damage, he is still responsible regardless of what precautions he had taken. So let's say that the independent contractors were aware of the mining shaft below and they had taken the necessary safeguards to prevent such a thing from happening, and it still ended up happening. Even then we can say that the owner has a responsibility over here, because no unnatural thing should cause harm to anybody else. Finally, the court held that whoever brings something unnatural onto his land and that unnatural thing is likely to cause mischief if it escapes, then that person will be held liable for the damage that thing causes. Now in this present case, it is the case of a reservoir meant for the purpose of holding water. What if I bring a Bengal tiger into my property? A Bengal tiger is unnatural if it is located here in Tamil Nadu. Yes. So I have every duty to make sure that that tiger does not escape and cause harm to other people, their pets or things or even others' property. Okay. The following Rylance versus Fletcher, there was a case of Reed versus Lyons, where they said that if we are applying strict liability principle, the following two conditions are necessary. One, it has escaped from a place which the defendant has occupation or over which he has control. So any place that he has control over, or he is residing, or he is occupying that property, if that unnatural thing escapes, then escapes and causes some mischief, then we can apply the principle of strict liability. There must be a non-natural use of land, in the sense that if there is a natural use of land, then this principle does not even apply. Now, what do you understand by the word of non-natural use of land or the natural use of land? For this, let's just look at the first exemption. That is, if a person is bringing something unnatural, in the sense of a Bengal tiger in Tamil Nadu, I'll call that as unnatural. But if the Bengal tiger is in the Sundarbans, then isn't that where the Bengal tigers reside, or is their natural habitat? So if a Bengal tiger enters into my property and resides there for a few days, and then from my property it attacks a person on my property, then that is a natural use of land. That is beyond my control if some activity happens. Okay, so in Reed versus Lyons, they said that the unnatural thing must have escaped from a property that the defendant has control over or has occupation of. Now, this is your rule of strict liability in the case of Rylance versus Fletcher. But in Rylance versus Fletcher, the courts actually held that there are 6 exceptions that we can give to you. 6 exceptions which, if you fall under these exceptions, then I will not impose a strict liability on you or for any unnatural thing which had escaped from the property. What are those 6 exceptions? Your first one is damage due to natural use of land. Okay. Now, they are saying that keeping water for ordinary domestic purpose is considered as a natural use. Please remember that in Rylance versus Fletcher, there was a reservoir. A reservoir is also meant to catch water. Okay, but then if you have a drum in your house, maybe a 5-liter drum in your house, which is again for the purpose of catching water only, the reservoir is considered unnatural, whereas the drum is considered as a natural purpose. Because even if that 5-liter drum falls down or the water escapes from there, it's not going to cause damage or harm to property or a person, correct? Whereas if the reservoir broke, so many people's livelihoods and lives were lost. So that's why they're saying keeping water for ordinary domestic purposes is considered as a natural use of the land. The second exception is consent of the plaintiff. Where the plaintiff himself has consented to the dangerous thing being on the defendant's land, then it is understood that the plaintiff itself has given his consent and that he has to take necessary actions to protect himself from that danger. Okay, so where there is consent, there is no case of strict liability. Third one, we have act of third party. That is, even though there is unnatural thing on the land and that thing has escaped, it escaped due to the act of a stranger who is neither the defendant's servant nor agent, and the defendant does not have any control over this person, but rather this person entered into the property and ended up causing that unnatural thing to escape and cause damage. So let's look at the case of Box versus JIGL. The overflow from the defendant's reservoir was caused by the blocking of a drain by the stranger. In this case, the defendant was not held to be liable. But if the act of the stranger is or can be foreseen by the defendant and the damage can be prevented, then the defendant must have, by due care, prevent the damage on his behalf, and failure to avoid such a damage will make him liable. Remember, in strict liability we said that the defendant will end up having a duty regardless, as long as that unnatural thing is present on his land. Okay, now if the stranger came and did something without the knowledge of the defendant, then the stranger will be held liable. But if the defendant could have possibly known that such damage can be caused, then he must take the necessary action to prevent that damage. That duty of care still falls on the defendant himself. Our next exception is the case of statutory authorities. Now, if you look at statutory authorities, we have public bodies storing water, gas, electricity, etc. Now, generally, statutory authorities are exempted from liability provided that they have taken reasonable care. Now, you may ask, ma'am, what is the reason for which statutory authorities are exempted? For this purpose, let's take the example of electricity. Okay. Now, to get electricity or to provide electricity to every person living in the visible area, they need to set up electric poles and electric lines. Now, these lines and poles will probably be put along a person's property or alongside the road also. Now, as long as the electric body has taken the necessary steps to or reasonable care in setting up these poles and lines, then even if this pole falls down or even if the electric line falls down and causes damage, because there is statutory authority, they are protected under law. Why is this? Is because the statutory authority has a duty every single day to provide electricity to the people. If they have to be sitting and fighting every case before the court of law or providing compensation every single time there is some kind of harm caused, then the body will be spending its time before the courts of law rather than actually carrying out its public duty, that is providing electricity. So, as long as they have taken reasonable and due care, we can say that statutory authorities are exempted from the concept of strict liability. Let's look at the case of Green versus Chelsea Waterworks and Company. The defendant company had a statutory duty to maintain a continuous supply of water. A main belonging to the company, that is, a main also means a pipe, the main pipe belonging to the company burst without any fault on its part, and as a consequence the plaintiff's premises were flooded. It was held that the company was not liable since the company was engaged in performing a statutory duty. Our next exemption from strict liability comes under act of God. That is, where the escape happens through natural causes and without any human intervention. That is, there is no possible way anyone could have known that such a wrongful act could have happened. Now, this itself has multiple ways of looking at it. An act of God is also, some examples of act of God are your tsunamis, earthquakes, some activity which is not supposed to happen. Like, what if it starts snowing in the Rajasthan desert? Okay, if it's an activity which does not necessarily happen all the time, or it has never happened in the past before, then we'll call that as an act of God. Okay, but if you go to Nepal or Japan, which are earthquake prone areas, then you have every knowledge that there is a likelihood of a earthquake over here. Now at that point you cannot call an earthquake an act of God, because you had every reason to believe that it's going to happen. It is only in a place, say in Karnataka. If it was Karnataka, it is not very prone to earthquakes. So if an earthquake happens over there, we can call that as an act of God. Our last exemption from strict liability is escape due to the plaintiff's own default. That is, if the plaintiff himself was the reason due to which this thing escaped, then this is an exemption granted under the strict liability principle. So let's just quickly look at all of the principles of strict liability or exemptions under strict liability. One is the consent of plaintiff, damage due to natural use of land, the act of a third party, wherein we saw the case of Box versus Jupe, statutory authorities, where we saw the case law of Green versus Chelsea Waterworks Company Limited, act of God, and escape due to plaintiff's own default. Alright, so this is only your case of strict liability. Now please remember that we are talking about strict liability because this concept was borrowed and applied to the case of the Bhopal gas tragedy or the MC Mehta versus Union of India. But remember, I said that in the case of absolute liability, the principle is slightly twisted or slightly changed. Why is that? This is because our judges wanted to apply this principle of strict liability to our country for the case of the Bhopal gas tragedy, but in such a way where rather than waiting for the damage to happen, they will put a duty on certain persons to prevent that thing from ever escaping. And more importantly, the court went on and said that in strict liability there are multiple exemptions. That is, if it's an act of God, statutory authority, etc. However, absolute liability will have none of those exceptions. Okay. So what is absolute liability? It's an extension of the rule of strict liability. While strict liability has certain exceptions, this rule does not. And the principle of absolute liability was created in the case of MC Mehta versus Union of India. What was held in this case? They said that if any industry or an enterprise, this is the very first difference that we see between strict and absolute liability. In absolute liability, this duty is being put on enterprises or companies. Companies which are engaged in hazardous or inherently dangerous industry. Whereas in strict liability, this applies to any one person who brings something unnatural onto the land. Okay. So if an enterprise is engaged in hazardous or inherently dangerous industry, which can harm the health and safety of persons either working at the factory or residing nearby, that company has an absolute and non-delegable duty to the community to ensure that no harm is caused due to the dangerous activity being taken by the enterprise. So over here we can say that there is an obligation. The enterprise is under an obligation to provide that the hazardous or dangerous activity in which it's engaged must be conducted with the highest standards of safety. That even if such harm occurs as a result of such standards of safety, the enterprise will still be absolutely liable to compensate for such harm. So there is a duty put on the companies, and there is, even if you carried out your duty, you took all necessary care, fair, reasonable, etc., you will still have to pay compensation in case there is a wrong committed. Okay, and this is what was held in the case of MC Mehta versus Union of India, also known as your absolute liability principle.